This is a violation of sections 3B and 4C. You have 24 hours to remove this obstruction or we will do it for you.
At 6:12 a.m. on May 3, 2024, I opened my front door and the chain snapped tight like my house was on a leash. Cold air hit my face. A thick chain ran through the handle, and a bright yellow padlock clacked against the metal with every gust. My driveway gate had another lock, same shiny yellow, same ugly message. A community patrol cart idled at the curb with amber lights blinking. Pavement smelled like asphalt and pine mulch, and my coffee tasted like pennies. 2 days earlier, the HOA president called about the creek behind my place and tried to sound friendly while she grabbed for control. HOA padlocked my mansion over riparian rights using recorded call, and their hearing lost was final became the sentence I hated repeating. They claimed the strip along the water was community access. I said it was on my deed and survey. It's deeded to my lot. Not shared. At 6:18 a.m. I called the HOA office and got voicemail, so I called the chair's personal number. She answered fast. I said, "There are locks on my door and gate." She sighed. "You're in violation. Riparian buffer. Unapproved work." I said, "You can't lock me out." She replied, "We can secure the property until compliance," then hung up. By 9:00 a.m. I was at the clubhouse with my deed printout. The board rep wouldn't look at it. The robe-wearing board member tapped her pen while the HOA president slid me a notice of non-compliance and said, "The board voted." Back home, I drew my line in the sand. No yelling. No stunts. Proper channels only. I filmed the locks from every angle with my address number in frame and the timestamp showing. I called the non-emergency line and asked for a deputy to document the lockout. The chain kept clinking like it was laughing. The deputy arrived at 10:11 a.m., took photos, and said, "This isn't enforcement. This is interference." That afternoon, I built a case instead of a meltdown. I lined up photos, emails, and call logs in a binder. I printed every fine notice, including the one that jumped to $2,000 in a month. I highlighted the bylaw section on penalties, because it talked about pool access and clubhouse keys, not padlocking homes. I emailed the board asking for the written vote that approved locks on a residence. They replied with one sentence, "The matter is closed." I drove downtown to the county records window, the one with scratched glass and a loud stamp. I asked for everything tied to my lot and the creek line. The clerk slid a stamped packet across the counter and said, "That's $20. The file landed with 74 pages. The plat map showed the creek strip was private. An amendment from 1998 said the HOA had zero authority over private riparian areas. The hearing was May 17, 2024 at 7:00 p.m., and the room smelled like burnt coffee and old carpet glue. They opened with a slideshow of my violations, blurry creek photos like I'd poisoned the water. The HOA president sat tall, smiling. I set my binder down, passed out the plat and amendment, and played the call where she admitted the locks were meant to force compliance and teach me. Her smile froze. The board rep stared at his laptop like it had betrayed him. Word moved faster than mail. A photo of my chained door hit the community chat, and the comments piled up. People asked if this could happen to any home. A mom wrote she was scared to leave town. A retiree said he'd gotten 6 warnings in 1 week and thought it was normal. Someone posted a shaky video of the patrol cart circling my driveway at 9:14 p.m. Screenshots of old fines popped up, 5 here, 8 there, 4 tiny stuff. In the hallway, phones came out like tiny spotlights. I heard whispers like, "That's not right," and "She went too far." Then the authority flip landed, calm and heavy. A county code inspector showed up because my complaint was tied to recorded plats, not clubhouse opinions. A deputy came too, because a lockout is a lockout. The inspector asked, "Who ordered the padlocks?" The HOA president started talking fast about safety. The deputy cut in, voice flat. "You can't deny someone access to their home. Patterns of false reports can be prosecuted." I read one labeled note, once, timeline item 1 April 5 at 4:27 a.m. false trespass call. The inspector looked at the dates, the photos, and the plat, and his pen stopped being polite. You could feel the room change like a bully losing oxygen. People sat straighter, shoulders back, like they remembered they were homeowners and not scared kids. The HOA president stopped smiling and started blinking hard, like the lights were suddenly too bright. The board rep went quiet and rubbed his forehead, because his script was gone. Phone stayed up, not hidden, because everyone finally understood that documentation was air. The inspector pointed to the county stamp and explained, slow and plain, that recorded boundaries beat board votes. Even the neighbors who used to avoid eye contact leaned forward. Nobody laughed. Nobody whispered excuses. A few heads nodded, like relief finally had permission. The room wasn't angry anymore. It was awake. After that, consequences arrived in plain language. The inspector issued a notice to the HOA for acting outside its authority on private property. The deputy filed an incident report for unlawful lockout and documented the chain placement. The HOA attorney asked for a recess and came back looking pale. At the June 1, 2024 meeting, he told them to rescind the riparian enforcement, stop direct contact with me, and refund documented costs, including the locksmith callout, because the county record was clear. The next weeks felt like the neighborhood waking up from a weird fog. People stopped ducking into garages when board members walked by. They lingered at mailboxes and compared notices like puzzle pieces, not secrets. Meeting attendance doubled, and folks came in pairs, sitting closer, asking for motions and minutes instead of clapping for speeches. Someone printed the enforcement limits from the bylaws and taped them inside the clubhouse bulletin case, and it stayed there all week. Phones stayed visible, like quiet body cameras, and the loudest voices suddenly had to stay honest. When the HOA president tried to talk in the chat, people replied with screenshots and dates, not fear. It was like the spell broke, and everybody remembered how to stand up straight. Now my creek is just a creek again. Frogs, what would smell after rain, and peace. The strip along the water stays mine, and the common trail stays common, without anyone cutting across my property like it's a shortcut. I keep that binder in a drawer, not as a trophy, but as a reminder that facts don't yell and they don't panic. They sit there until the right moment, and then they do the talking. If you enjoyed this, hit like, subscribe, and share. Was the HOA wrong? Drop a comment.